Good afternoon and welcome to Be Informed. My name is Carl Buhariwala and I founded Be Informed to help people make good decisions. Today the session's on child abduction and we are joined by Arthur Athan of Meave O'Brien and Associates and Ek Taghdir of the Victorian Bar, who will be speaking to us today about the Australian legal principles on child abductions. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to their elders past and present. Today's session is being presented in Australia and will be in consideration of the Australian legal principles, the Australian jurisdiction. So if you are viewing or joining us today from a location outside of Australia, then you may wish to consider the applicability of the legal principles. The information in today's session is current as of this month, and the information is general information only. So if you do have any specific queries, you may wish to engage with a solicitor or a lawyer like Arthur, who can then help you through the queries that you have. Now, today's session is being recorded, so if you do have to drop off or leave early, that's fine. You can watch the entire session on our YouTube channel later today and moving forward. And the presenters, Arthur and Ek, have kindly prepared a one-page handout, which I'll be sharing with registered participants following the closure of today's session. In terms of housekeeping, if you do have a question, please raise it through the chat function to me, and I will then relay the question to Arthur and Ek for them to consider and respond. And the session will run for the seminar component will run for about 25 minutes, after which we'll then proceed into Q&A, and then the session will wrap up just before 2 o'clock. So with all that in mind, and I know Arthur and Ek are eager to get going, I'll now hand over to them. They can introduce themselves and then take us through today's seminar.
Thank you, Carl. Much appreciated. And thank you for the invitation to present yet again for Be Informed. Very honoured to have Ek join me in presenting this short seminar on the important issue of child abductions by a parent. Very conscious about you as an audience who might not know anything about this topic and might not know anything about child abductions, or you may have experienced this. We're very conscious that it's a topic, it's an issue that can be extremely traumatic. The situations that are involved with child abductions by a parent are often fueled by a lot of conflict, and we're conscious of that as we speak about it today. Ek and I have an interest in this topic. We've dealt with cases in this regard in the past, particularly in relation to non-Hague Convention countries. We'll explain that whole topic, what Hague Convention means, and what the implications of those are a bit later in the presentation. That's our interest area, and the other thing that we want to note just from the outset is that the facts that give rise to child abductions by a parent are extremely unique. They're factually so diverse, and ultimately, if that's you considering this issue in your own family, or you've never considered it, the most important thing is to seek legal advice. Seek legal advice that's specific to your situation. The purpose of our presentation today is to provide you with information about this issue so that you've got a basic level of understanding, but we encourage you, obviously, to seek legal advice if you're in a situation that involves a child abduction by a parent. Carl, if you don't mind just switching to the first slide. Thank you. So first slide, separation and the risk of child abduction. First point there is we've got to consider what is separation. Started at basics here. Separation is essentially what occurs when there's very clear verbal communication between parties, or it can be defined by conduct, by, for example, parties moving out of a matrimonial home. It's the act that that essentially defines the end of a relationship. Now, there might be disputes about dates of separation, but that is essentially what separation is. In terms of child abduction by a parent, we're talking about the unauthorized and not permitted taking of a child, usually to an overseas country, can be interstate, but today we'll be dealing with international child abduction. And when I say unauthorized or unpermitted, what I mean by that is that there is no consent between parents. We're talking about a situation where there are no agreements, no written agreements, no informal agreements. It's usually a situation that takes the other parent by surprise and often causes a lot of anxiety and worry about the situation. The next point that I've got there is be aware, from the outset, let's be aware of risk factors that may hint at a child abduction by a parent. When I say risk factors, again, it's so specific to your situation. Some of the risk factors that we've brainstormed and that we've come across can include the level of acrimony, so the history of conflict between parents, the level of communication between parents. Sometimes that's some of the facts that might arise. The other factor that we've thought about is ties to different countries. There are many, a lot of us are migrants in Australia. Some of us are Australian citizens. Some of us have different levels of residency status, depending on our visas. And as a result, there might be different levels of ties to different countries internationally. This could mean that you've got people who are born overseas, who are citizens overseas, who have family overseas. These are facts and factors that you might want to consider when assessing some sort of risk of a parent potentially taking a child without consent overseas. The other factor I've got down here is finances and assets. And what I mean by that is where are finances, where are assets held, essentially. And what I mean by that is if there is a parent in Australia who owns property in Australia, a court might consider a risk in terms of abduction to be a little bit less, a lower risk, in the sense that they have ties to Australia and they potentially don't intend to live overseas and relocate overseas. That it's highly dependent on a case-by-case basis. However, that's a consideration in terms of assessing the risk. Where does family reside? Cover that a little bit, and also citizenship and visa status. So those are just a couple of facts that you might want to consider. The next point I have there is, what is the 1980 Hague Convention on the Civil Aspects of International Child Abduction? It's a very long name for an international treaty, but essentially what that refers to is a treaty that many countries have entered into and signed up to around the world for an agreed set of rules for how to deal with international child abduction. Australia is a signatory. You can very easily Google search the Hague Convention and be presented with that list of countries. The reason why the Hague Convention is relevant is for signatories to the convention, those signatory countries have essentially an more or less agreed pathway for how to proceed where there is child abductions between those signatory countries. The convention is quite detailed. I would encourage you to have a read of it or seek legal advice about that. In the case that you're presented with this situation, the reason why this is relevant is if there is a child abduction that involves a Hague Convention country, there is an agreed set of rules generally. If there is a child abduction to a non-Hague Convention country, there are no agreed set of rules for countries to follow and deal with that type of situation. Ek and I have recently dealt with a situation that involves a non-Hague Convention country, and we'll talk about that a little bit later in this presentation. The next step is if there is evidence of a risk of child abduction by a parent, seek preemptive legal advice immediately, be proactive and cautious. I think that speaks for itself, and that'll be a theme that we'll keep on reiterating throughout the presentation. And finally, that if a parent abducts a child, seek legal advice immediately, just to make the point. Let's move on to the next slide. Thank you, Carl. Appreciate it. All right. Just beginning here at a Hague country, a Hague Convention country. What I mean by that is a country that is a signatory to the Hague Convention. For the purpose of this discussion, let's pick the United Kingdom as an example. And that's, as our first point says, an example where the child has been abducted to the United Kingdom. The first point that I like to make is if the situation is not urgent, and assessing urgency is again very discretionary, and it depends on what the court considers to be urgent. I'd put an example there, for example, an overseas wedding or an overseas funeral. The first port of call there is to attempt to reach agreements through a lawyer and have those agreements formalized and made binding. In terms of how we make those agreements made binding, generally that's parenting orders by consent. Alternatively, an undertaking could be given. And in terms of recourse for enforcing those type of arrangements, that involves obviously the court. In terms of parents being accountable to the court for orders made by the court or undertakings given to the court. If the situation is urgent, and what I mean by that is that there is a risk of abduction and the unauthorized taking of a child without consent, or alternatively, if there are no agreements reached and a child has been taken or is about to be taken, then there is a possibility that it might be necessary for you to issue urgent court proceedings for a recovery order. It's important to note that when court proceedings are issued for an urgent court recovery order, the assessment for urgency is up to the court. That's the first thing, but also be aware of the involvement of the Federal Attorney General's Department as the Central Australian Authority and the Australian Federal Police. What I mean by that is in the convention, there is, it names it has a category for the central authority of each signatory country. And for us in Australia, that's the Federal Attorney General's Department. And that department would be communicating with the relevant overseas central authority to work together cooperatively to effect and implement any recovery orders made. Without going into too much detail there, just the final point, if a child is recovered pursuant to a recovery order, it's important to note that your court proceeding will not be finalised until final parenting orders are made. Generally, a recovery order is made on an interim basis. It's an interim order, and that is generally still at the beginning phases of a court proceeding. It's not finalised until final parenting orders are made. That includes and considers a whole range of different matters that are in the best interests of children involved. Thanks, Carl. We'll just move on to the next slide there. Thank you. Okay. So moving on from there, we have the situation of where a child is abducted to a non-Hague Convention country. For the purpose of this discussion, we'll use a country such as China. China is not a signatory to the Hague Convention. Therefore, it falls outside of the agreed set of international rules there. Similarly to the previous slide, if the situation is not urgent, for example, in an overseas wedding, it's important to have that first discussion to see whether binding agreements through a lawyer can be made. However, obviously, because the country is not a signatory to the Hague Convention, the risk the risk level might be higher in terms of agreements, and the fact of the matter is that such agreements may or may not be enforceable in China, using China as an example, depending on Chinese law. So it's important to note that even if agreements are reached in relation to the return of a child or the child being overseas in China for a certain period of time, it doesn't necessarily mean that us in Australia, under Australian law, and if you're appealing to Chinese law, which we can't advise on, those agreements may or may not be enforceable. If the situation is urgent, for example, there is an imminent abduction risk or it has already happened, or if agreements are not reached, again, seek legal advice from an Australian family lawyer, such as myself and Ek as counsel, and importantly, seek advice from a Chinese family lawyer. This is incredibly important. Just following on to the next point, if the Chinese family lawyer advises that an Australian court decision would be enforceable or influential in China, you may want to consider issuing court proceedings in an Australian family court for a recovery order. When I say that the Australian Family Court, I'm meaning the Federal Circuit and Family Court of Australia. That's an important final point. Without that advice from a Chinese family lawyer, you may or may not be advised that issuing a court proceeding here in Australia would be advisable or not. Ek, at this point, I'll just turn over to you to add any comments there, and Carl, I'll just let you move on to the next slide where Ek can take it away as well. Thanks.
Well, firstly, grateful to be here, and thank you, Carl, for inviting me on your presentation. It is certainly a very emotional topic, as Arthur has mentioned. Usually when we talk about child abduction, one scenario that ordinarily comes to mind is a stranger stealing your child. But the unique situation in family law cases is that it's really another parent unilaterally making a decision to relocate the child to another location. And in this situation, we're talking about an international location. And if it was a case of a stranger abducting your child, you'd imagine a strong reaction by almost every authority, the media coming in and giving as much assistance as they can. But in this scenario, people are usually left a little bit isolated because there won't be that reaction. Well, a parent has taken a child overseas. What's the problem? So then the person is left with little recourse but to see what options they have left. And that's why there's this emphasis of seeking legal advice as soon as possible, whether it's before the abduction has happened or the unilateral decision has happened, or whether it's after, because the more you leave it, the more difficult it becomes to really do anything about it. The other commentary I suppose I would make is just to emphasize the difference between Hague and non-Hague convention. Hague is really just an agreement between countries that they'll first decide where the court hearing should take place. So the first question will be, where did the child really live? And if an Australian court, for example, or a court in the UK says, well, look, the child was really living in Australia, then the court over there would decide that the child should be sent back to Australia for all parenting matters to be decided in Australia. Or alternatively, the UK court might say, well, look, 2 years has passed since the so-called abduction. The child is now living in the UK, and therefore we're going to hear the parenting matter, right? So that's the difference between a Hague and the Hague. That's the Hague Convention. But in the circumstances of a non-Hague Convention, where the countries don't have that agreement or they're not signatory to that treaty, then really the only thing a person can do is decide, well, what legal recourse did I have in that country that the abduction has happened? So in this case, it's China. So as Arthur was saying, you'd have to really decide whether you can go to the Chinese courts and really press your parental rights over there. And that's where it's really important to seek that advice from a qualified lawyer in the Chinese jurisdiction, for example. And they might tell you, look, an Australian court order would be helpful or influential, or might even sway the courts over here that the child should really go back. And if that's the case, that's where Arthur and someone like myself can assist in getting appropriate court orders for the return of the child to Australia, and those orders might be influential in China. So one of the things in these sorts of matters, in any court matter, there's this issue of service, and really what that comes down to is finding out where the person is, because sometimes in these cases when there has been an abduction or a unilateral decision to take a child overseas, the person doesn't really disclose where they are, that parent who's taken the child. Now, sometimes you might know where that parent is relocated to, because you know where the grandparents lived or the family members lived, or you may have visited there. But in other cases where maybe one of the parents has never been to that country and they met in Australia and they lived all their life in Australia, they don't know where they are. So one of the biggest challenges, the initial challenges, is finding where that parent is, because the Australian court is going to be very interested to know. That person would need to be served with all the court documents. One of the premises in Australian courts is that there can't be any palm tree justice. And what that means is you can't have surprise attacks. People have got to know what the case against them is. So it's going to be really important to try and find them. And that raises some ethical and legal issues, how you're going to try and find them. Now, it's very important, and all we can advise is that you follow the laws of that local country. You don't want a case like the Faulkner case back in, I believe, 2016, where the 60 Minutes crew went to Lebanon and they got into all sorts of strife, where they didn't follow the local laws, because there's not much anyone can do. So really, from an ethical perspective and a legal perspective, not to get yourself into trouble, you'd really have to follow those laws. And, whether they permit private investigators or they've got their own mechanisms through the authorities there to locate the person, that's a channel that needs to be advised. Then there's, of course, the issue of the costs involved. Now, Arthur might speak about that a little bit more, but really it's a question of how effective is this Australian court order going to be? And that will depend on what advice you're given by for example, a lawyer in China, and how much you want to spend, because it can be an expensive exercise, not just the legal proceedings, but the recovery itself. Think about going to that jurisdiction, paying for accommodation, paying for flights, staying there, and ultimately engaging anyone you need to engage to find the person, find the child. These are the things that one needs to consider. Then the other aspect of proceedings in Australia is, once you've found out where the person is and you've located them, the court wants to know, do they know about the Australian court proceedings, which has the aim of basically seeking a recovery order which might influence the government in China or the courts in China. Do they know about the Australian court proceedings, and have they had an opportunity to respond? And again, that comes back down to ensuring they know what the case against them is, because in fairness, there might be some cases where someone's made a unilateral decision to relocate for a good reason, and that might include issues like family violence or any other matter where the court will just over here will be interested in giving them an opportunity to explain what the situation was. But of course, if they don't participate and they don't engage, then the court has the option, or it has the basis of just considering the evidence of the person seeking a recovery of the child. So that comes, I think that covers the 2 points of making sure the person is served, they know what the documents are, making sure they are aware of the case against them, and the issues of language and translation. What we're really getting at over there is that when you get your advice from lawyers in another country, in this example, China, you want to make sure that when you get that advice and it's supplied to your Australian lawyers, it's properly translated. So we know what to tell the courts over here, because going through the technical maze and the technicalities of the legislation and the law, one of the requirements is to see whether the Australian courts will want to know if there's some form of conflict between the two laws. And that's why it's very important for us to have a proper read of what the Chinese law says based on a Chinese expert, and that's a Chinese lawyer. So translation is going to be very important, and to make sure it's a proper translation, so there's no we don't misconstrue it or we're not misguided by it, and that's going to be very important. Then we've got the issue of obtaining evidence in accordance with Chinese law, and that raises, I suppose, two topics. Yes, evidence needs to be attained, listening to the local law and complying with the local customs or laws, whatever they may be. But also, what that really is getting at is that emphasis that the courts over here will be interested to know what Chinese law actually states. There might not be an issue. There might be, for example, the law over there might say that the child, regardless of the Hague Convention, needs to return to Australia, for example. And it's important for the courts over here to know that. Conversely, there might be very rigid laws, and the Australian the courts might customize an order which is not demanding, and it's very important that what you achieve over here are not court orders demanding the foreign country to do something, or telling them what to do, telling them to return the child. It will be requesting them to assist in recovering the child. And that's, I suppose, a very important point. But and that really comes down to how that recovery order is drafted, and that's why I have to emphasize, and like Arthur has and Carl has, every situation is case by case. No two cases will be the same. No two countries will be the same. Even from the same country, you might get a lawyer that gives you expert advice one way and another lawyer that gives you expert advice in another way. So it's very important to know what the case is, and that would inform someone like Arthur how to draft the recovery order. I hope that was a good nutshell on my side, so I'll hand it back to you, Arthur, and
thanks.
I'll drop in again.
Absolutely. Thanks, Ek. Just following on from what Ek has said on 2 points. In terms of legal costs, we're under no illusions that issuing a court proceeding in the Australian jurisdiction is expensive. It's got to be justifiable, and we, as lawyers, are responsible to provide that advice and give you advice about essentially the cost of the proceeding and the benefit to you. Now, oftentimes when dealing with parenting matters, when dealing with children, we're dealing with issues that are extremely emotional, extremely sensitive, and sometimes for many people, you can't put a price on that. However, the economic situations of different people might be extremely different, and that would obviously play into a decision as to whether a court proceeding would be issued. But importantly, I think for our discussion is in weighing up the cost and the benefit of such a proceeding, it does really turn on the evidence and the advice that is received by the overseas lawyer. Again, just reiterating a point from an earlier slide, if advice is given from the overseas lawyer with regard to an Australian court decision being influential or enforceable in the overseas country, then our advice here is let us help you to obtain everything possible under our legal system to assist you in the overseas country jurisdiction. And my advice would be obtaining an interim recovery order, or even on a final basis in the Australian jurisdiction, albeit expensive. It might be extremely helpful for your overseas family lawyer when it comes to enforcing that and ultimately recovering the child being the ultimate goal. Ek, did you want to raise anything there?
I did. And what I suppose a comment that needs to be made at this point is that, and where I didn't finish off, what the Australian courts are going to be looking for when they want to make a decision to grant a recovery order, and they will try and be helpful. The real question is, was the child living in Australia when at the time the application is made, or considered to be what's called a habitual resident of Australia? And once the court satisfies themselves of that, they'll be very inclined to be helpful based on the circumstances and to hear your case out. So it's not the end of the inquiry, because the court will first want to work out, is the child a habitual resident? Simply meaning, was there a stable home? Was Australia home at the time the application was made? And if it was, the court's going to ask, is it in the best interests of the child to return to Australia and to live with the parent that is in Australia? And why I mention this is that it's very important to act as soon as possible, because the more time that is left from making the application, that status of habitual residence can change. So say, for example, a child was abducted, a month ago. On this day, the court might consider the child was a habitual residence, and they'll be inclined to, I suppose, help and make orders based on the case that's put forward. But if, for example, 2 years goes by, then the court might not be so inclined to consider that child a habitual resident of Australia anymore, regardless of whether they've gone to a Hague country or a non-Hague country. So really, in considering the costs, which we've acknowledged that it's not, it is an expensive exercise, the more you leave it, I suppose the greater the expense is. So it's best to act as soon as possible and at least see what your options are by speaking to a legal practitioner.
Thanks, Ek. One final point for this slide. We've already covered the situation, the topic of procedural fairness, of essentially service of providing the other parent with notice of the proceeding, making sure they know of the case against them. I want to acknowledge that this may seem extremely unfair to the parent who does not have the child, whose child has been unilaterally taken away from them by the other parent. It might seem extremely unfair to provide the other parent, the parent who effected the abduction, with notice of the court proceedings, of the legal avenues that you are exploring, especially in light of the actions that have been taken by them. I can only reiterate what Ek has already said. Procedural fairness is a premise of our legal system. It is important that they have notice and they understand the case that is against them. Did you want to add anything to that?
No, I really just have to emphasize that point. It feels it's very raw for a parent whose child has been taken away, and there's always that risk that if they find out about it, well, they might pile and hop and go somewhere else, and there is that risk. But from our perspective, the best cure is to just act fast and act as strategically as strategic as possible to ensure they know about it, and there's enough time that the court over here knows that they know about it, so that effective orders can be made. And that works hand in hand by ensuring that you've gone to the local jurisdiction like China and made sure that there's something occurring over there, whether you've sought legal advice and maybe you've gone to the local authorities over there and they've kept the track of them all within under the umbrella of legality under their laws. So these are the sort of things you can do, and that someone like Arthur and myself would work hand in hand with you to ensure we're guiding you in the correct way so that we can ameliorate those sorts of risks.
Thanks. Carl, if we don't mind moving to the final slide. I'm very conscious of the time as well. Thank you for the bit of extra time just to finish up. In conclusion, it's important to seek legal advice, very, very important, as early as possible. Again, be aware of the risk factors. Have conversations with family close to you. Even if it's possible and if it's safe to do so, have conversations with the other parent. That's highly case specific, and I suggest that you seek legal advice about that before doing so. And finally, in terms of your child's passport, it might be wise to hold that. Again, seek legal advice about your current situation, and birth certificates as well. That's we've experienced that proving, for example, a very simple thing of producing a birth certificate in a court proceeding is important, and can often be overlooked, I think, in many parenting proceedings. If there's anything else to add, Ek?
Arthur, Carl, I'd just like to emphasise seek legal advice.
I think that's the theme.
That is a massive point.
Yeah. If it's you going through a situation like that, please do not hesitate to reach out. We're here to guide you through the process. Thank you, Carl.
Thanks, Arthur, and thanks, Ek, for such a great presentation on the Australian legal principles, considering both sort of Hague Convention countries and non-Hague Convention countries, and I definitely acknowledge that this can be a quite emotional topic to discuss, especially if you have experienced this or are experiencing it. So if you do have any further questions, Arthur's details are on screen, and so Ek's details as well. Arthur and Ek are both Australian legal practitioners. Arthur is a solicitor, Ek a barrister, and they work together in relation to matters that they engage in. So that's the seminar, and just a reminder for those who have joined late, the session is being recorded, so if you do want to watch the entire session, you can on our YouTube channel following today's session, and there's also a one-page handout which Arthur and Ek have kindly prepared for those that have registered, and I'll be sharing that by email after the session as well. All right, so let's jump into Q&A, and Arthur, Ek, we've got a few questions. So first one, just around for the non-Hague country, how when you sort of have to engage with the overseas jurisdiction's legal system and engaging a lawyer there. Do you recommend individuals sort of do that themselves, or do you, like this local legal practitioner, assist with that and make any recommendations? Like, how do we do that sort of from an operational perspective?
I'm happy to answer that from the outset.
Absolutely.
In terms of engaging the overseas family lawyer, I've seen clients off their own bat make their own inquiries and engage an overseas family lawyer. Alternatively, I think that it's probably our preference to make sure that there's quality legal advice being given, not knowing the diverse nature of different legal systems overseas and different levels of legal expertise. I would generally recommend family lawyers who are members of the International Academy of Family Lawyers. It's an internationally renowned group of lawyers who have expertise dealing with their own parenting laws in their own country, but also there's a collegiality and familiarity with members that would assist, I think, in terms of international child abductions. That would be my recommendation. At the outset, seek legal advice from your Australian family lawyer, obtain recommendations, and then proceed overseas. That would be my recommendation.
I would certainly agree. I think be guided by your Australian family lawyer, simply because what you're trying to achieve, I suppose, from our perspective is, appropriate orders in Australia, but you also want assistance in the local jurisdiction or the international jurisdiction. And one of the benefits of asking, for example, someone like Arthur, is that lawyers recognise other lawyers, regardless of the jurisdiction. The law might be different, but once a person has handed us a couple of letters from the other lawyer, we can tell from dealing with local lawyers over here or other lawyers internationally whether their conduct matches up with someone who's acting professionally or very robustly. And we might just give a view on that without actually giving advice on the international, their local law. We can just see if their conduct is going to be helpful or not. And that's the only comment I can make.
Thanks, Ek. Yeah. Thanks, Carl.
Yeah, sure. And just on that point, how do we ensure that the overseas the parent that's abducted the child to an overseas jurisdiction engages a different lawyer? Is there the conflict checking process over there? Is that something that sort of the lawyer needs to sort of take carriage of, or should the parent be making their own sort of checks as well to ensure that the same lawyer is not making for both sides? Like what are your thoughts on that?
It's a great question. I would have thought, look, that would be a matter for the lawyer over there, you know, what ethical requirements they have. But I just would comment that it would be a great thing if it's found out that the other person has engaged a lawyer. That makes the job, I suppose, a little bit more easier from our end, on everyone's end, that they're actually taking this seriously and they, have engaged a lawyer. It'll be easier to communicate with them. It'll be easier to afford them procedural fairness, let them know, find out where they are. So that makes it much better. But to specifically answer that question, that would be a matter for the overseas lawyer and what requirements they have to follow.
I would agree.
And one question that we've got, and I think you touched on it as well, that whole point about procedural fairness, Arthur, you raised as well, that it can also be, unfair as well to the individual that's left, without their child, and then giving effectively notice of proceedings occurring. And then that parent that has abducted a child to an overseas jurisdiction then moves that child along to another country and probably just, goes around. Have you ever come across experiences where you've had to deal with that with your clients, and when does it stop? Are there ways to then sort of, seek recovery orders from multiple jurisdictions? Like, how do you deal with that sort of scenario where the abducting parent sort of takes the child and moves them along unknowing to the other parent?
I'll start, and then maybe you can carry on.
Great point to make.
Okay. Yeah, sure. It's highly case specific, Carl. Very, very case specific. I think that it really depends on the motivations of the abduction parent, and in my experience and in my view, I've raised the risk factor of ties to a country. Generally, I wouldn't have thought that an abduction parent would be moving around too much, but it's very much fact dependent. Ek, do you want to cut in here, and I'll form further thoughts?
Of course. You make an interesting point that there is that island hopping risk, and if that specifically occurs, well, let's just say they jump from China to another non-Hague country. Well, the only thing we could say is the same process would follow if we know where they are and somehow you found out. It does become a little bit difficult for them because, look, people have finite resources, right? But one of the points I wanted to raise was this: that even if you would obtain an Australian order, and you've gone through the process and you've been quite successful over here, and you go to, for example, China, and you've started the process there, you've given the court orders, and, let's just say that it's a bit more difficult over there. One of the advantages of completing the process over here, despite it having maybe little influence in China, is that one day that parent might need to return. Okay? And it won't mean that these Australian orders have meant nothing. It shows I suppose, from an Australian perspective, it shows that you haven't put your head in the sand, right? And you've taken action. And if they do return, one of the things that can be sought in Australian order is an airport watch list on the actual parent from being able to, for example, leave Australia again. So, when people have lived here for a while, there might be good reason they need to come back, whether it's for finances, there might be a bank account they need to close, or just see a friend or a relative. And, that might be in 3 years' time, but it's better to have it than not have it. And that's the Australian court order. Yeah.
And Carl, just as a further point, it may be very difficult to locate a parent overseas as well. That's the reality of it. It may be very, very difficult, and that is something that is very case dependent.
Just on that challenge, Arthur and Ek, obtaining the parent and the child, or the parent and or child, it could be, the parent might have taken the child overseas and the child could be staying with grandparents or other family. But just in relation to that challenge, what orders can, aside from the recovery order, but what orders can be sought in Australia that potentially could be enforceable and influential in the overseas jurisdiction to help search? Is there anything that can be done there, or is it all dependent on what that overseas lawyer says and what they can sort of do within their own channels? I know you touched on that in the presentation. Are there any orders that can be sought here which sort of accelerate or, I know you said like they seek the assistance of, but is there anything that can be done to sort of demand or get more traction in that foreign country so that there can be a search happening for the parent and or child?
I would say, firstly, it depends on the advice given by the overseas lawyer as to what is helpful from our Australian perspective. I would say that the Australian jurisdiction is it's limited. It's limited when it comes to non-Hague countries, in the sense that Australia is not necessarily, as a jurisdiction, it's not going to tell other jurisdictions what to do, and it doesn't have jurisdiction to do that. Hence, Ek's wording in terms of drafting the appropriate orders that request the assistance of the authorities in other jurisdictions. Again, we are in that regard, we're guided by the advice from the overseas lawyer as to what is actually useful when crafting the orders that we're seeking in the Australian jurisdiction. Ek.
And sometimes that advice from let's say the so-called Chinese lawyer, they might hint at what's important in their jurisdiction. So they might say something like, look, regardless of the child's age, the child's wishes are going to be very, very important in that jurisdiction. Whereas Australia says, look, the child's wishes are important, but it depends on their age, right? What would become important when achieving during the Australian proceedings is not just the orders, but, for example, commentary by the court. So if there's a judgment by the court, the Australian the judges and justices, they're very good at what they do. They're very mindful of the ambit of the Australian legislation. So maybe within their judgment, they would include commentary by request, right, which alleviates any concern for that foreign jurisdiction. So they would perhaps make commentary that if the child was to return over here, that's not the end of the inquiry. We still want to know, for example, what the other person's case is, and it's going to be very important to us that what the child's wishes are in accordance with our own legislation. So it might not be answering your question, but these are the sorts of things that are important to know what the foreign lawyer is saying, or what that expert advice is, so that we can not only craft our orders in a certain way, but our case in a certain way, which would then be influential to what judgment is delivered over here, which again in turn is going to be read by that jurisdiction and properly translated, no doubt.
Specific to your question in relation to orders for searching and locating, we're very much guided by what the overseas lawyer says. That's my view.
You're really in another jurisdiction over there, and we've got to see what the equipment over there is. And
Correct.
It might be something that surprises us, and hey, if it's legal, it's legal.
That's right.
We just don't know the answer to that.
And reiterating what we've said before, our advice is to act in a legal manner, to follow the laws of Australia and the laws in the overseas country. That's important.
That's right.
Yeah, definitely. Final question before we wrap up. You mentioned, of course, identify the risk factors that might hint toward an abduction, and act early and seek advice. If the risk is high, seek advice early, right? Hypothetically, the child is still in Australia, potentially a parent's thinking the other parent might abduct. What sort of steps can that parent take to put a stop on that parent taking that child outside of Australia? Is there anything that they can do to ensure that that child doesn't leave the border?
I'll let you answer that question about what you can do, but in terms of finding out whether you should do something, it starts with a conversation, really. So if the person or a parent is intending to take a child overseas, whether it's urgent or not urgent, or there's an inkling that they might, you can't just go, for example, and slap an airport watch list order on. The court will want something more. You can't just act on inklings or suspicions. But that's where a conversation with the other parent, if it's safe to do so, is very important, because that conversation will guide you as to how serious they are being. So, for example, if you go up to them and quite rightly say, look, you're going to a jurisdiction that, is quite perhaps questionable, and, we've been through a lot with each other in our separation, I'd like some sort of agreement. How that parent engages or responds to that line of inquiry might inform you about whether the risks are high or it's not high, right? And I'll leave it to you. What can we do if?
And again, seek legal advice about your specific situation. That conversation may not be appropriate, and depending on the situation. But ultimately, what we're reiterating here is that there's got to be. We need evidence. We need evidence of some sort, and it's going to be more than just an inkling. It is possible on the practical front, if there is a concern about an imminent child abduction, to seek advice, issue a court proceeding, and seek an order for an airport watch list. And what that means is a child practically is placed on a list that is basically controlled by the Australian Federal Police, and that by obtaining that watch list order, in terms of a child leaving immigration points throughout Australia, they would be barred from doing that. Essentially, the Australian Federal Police would hinder that the passage of travel. Essentially, in terms of obtaining that airport watch list order, it can be obtained simply by making an application to the court and serving that application upon the Australian Federal Police, without waiting for an interim airport watch list order to be made. However, in terms of substantiating that and the duration of such an airport watch list order, that will depend on a court's assessment, and that depends upon the evidence that you have in order to support your concern for the abduction risk. So I think that just covers the practicalities of how you go about preventing an abduction, essentially, from occurring preemptively.
With an emphasis on seeking legal advice.
Absolutely.
Beautiful. All right, thank you both. That now brings us to the end of today's session. Just like to share Arthur and Ek's details again on the screen. So if you do have any queries, I guess in the first instance, speak to Arthur or any other legal practitioner that you wish to engage. It's important that you seek legal advice early in these matters. This is highly complex, and you need to be strategic as well as to how you deal with the situation at hand. So those are the details of Arthur and Ek. Thank you both again for your time today in sharing some information about the Australian legal principles on child abductions. This brings us to the end of formalities. So just as a reminder, today's session is being recorded. So if you have joined late or had to leave early, you can still watch the entire session on our YouTube channel later today. And there's a one-page handout which I'll be sharing to registered participants by email. So you'll have that handy reference on hand, which also includes Arthur's details and Ek's details as well. Please do follow us on social media. We rely on word of mouth. If you have found this session enjoyable, or you've learned something from it, or can share some information with family and friends, please do share it with them, or get them to follow our page as well. And that brings us to the end. So thank you so much for joining. Thank you to Arthur and Ek for their time. And hope you all have a great afternoon.
Thank you, Carl. Pleasure.
Thank you, Carl.
Thank you both. All right. Bye for now.